For my final presentation, I decided to expand a little bit upon public performance rights and PROs and how that specifically relates to DJs and EDM. So in me and Logan's presentation, prior to this among performing rights organizations and performing rights, we asked a question at the end regarding if an EDM DJ were to play a song live and it would be okay versus it being taken down on a streaming platform. And so today I'm just going to talk a little bit more about copyright and how that plays into DJing in the live performance setting and eventually online. So a little bit of background from me and Logan's original presentation. The right of public performance is one of the exclusive rights that's in the bundle of rights. And so there's a few different things that make up a public performance. So the technical definition is to perform or display at a place open to the public where there are a substantial number of people. And in our presentation, we expanded a little bit on the fact that the substantial number doesn't necessarily have to do with sheer quantity. It has to do with the potential for it to be seen, basically. And then transmit or otherwise communicate a performance or display by any means of a device or process. So that's dealing with a little bit later when technology and streaming services led to the establishment of public performance being online, basically. So what is a PRO? A PRO stands for the Performing Rights Organization. So in our previous video, we talked a little bit about the first case that happened in the US. So performing rights organizations originated in France, actually, but the first case in the US was this Supreme Court case of Herbert versus Shanley. And basically a group of composers had walked into a restaurant, at Shanley's restaurant, and Herbert realized that his song was being played and he wasn't getting paid for his song being played. And so this Supreme Court case, the ruling basically wound up establishing that Shanley's restaurant should pay a fee for her playing his song during dinner. And this establishes performance rights as an actual right, so it establishes protection for those performance rights, whereas before they were only being protected for the mechanical rights. And Herbert actually went on to become the founder of the first PRO in America, which is ASCAP, and it's still one of the main PROs today. So PROs today, 3 major PROs exist in America. So that's ASCAP, as I mentioned, BMI, and CSAC. ASCAP and BMI are both considered not-for-profit, versus CSAC, which is a for-profit organization. But they all operate with the same goal, and that goal is to issue licenses on behalf of copyright owners and distribute royalties from public performance to the owners. And the Digital Performance Right and Sound Recording Act was passed in 1995, and this is kind of an additional way that artists were recognized that they should be paid for their songs being played. So it grants sound recording copyright owners the exclusive right to perform their works by any means of digital audio transmission. So this is to keep up with technology, basically. And so by that definition, streaming and streaming services are considered a public performance, and those are paid to PROs just as every other public performance. So, and a little bit of background on technology and DJs. The current technology has made sampling in music easier, and so the use of sampling has increased, especially within the electronic music sphere having to do with DJs. So digital DJ technology has kind of led to these hybrid DJ live sets becoming more common. So they're playing acapellas or samples over tracks, or there's a specific software console thing called Native Instruments, and it allows you for stems, which takes little chunks of songs, so that allows for the recreation of remixes to be performed live because they can save those chunks. And then Ableton also allows users to combine songs, samples, and stems to create new compositions live. So this is something that's very prevalent in the electronic music sphere. If you go to an electronic music concert, most of the time these events, the DJs will play a set where maybe a good quarter of the songs are samples from other songs, and upwards of that as well. So the legality of this, a little bit of background, if you remember from original copyright law, like definitions and things. For a work to be copyrighted, it has to be fixed. So the way we define fixed is stored on some medium in which it can be perceived, reproduced, or otherwise communicated. This can be like writing something down, like recording a little note of piano notes on your phone, something like that. And then having to do with like audiovisual works, a work consisting of sounds and images or both is fixed if the work is made simultaneously with its transmission. So this is like if you're recording a video and you're recording the video and audio and it's being, let's say, live streamed, that's fixed because it's being recorded and made at the same time. And so in the US, DJing is not considered a fixed medium just because since it's a live performance, it's not directly reproducible or distributable. And so that's kind of how up until this point copyright has gone for DJs. If they're playing in a live setting, they have a lot of freedom to use other people's works, that sort of thing, transform it however they want because it's not considered a fixed medium of expression. So in addition to this, the other reason why this is kind of considered okay is because most venues and festivals pay for a blanket license from the performing rights organization. So a venue would pay BMI, pay ASCAP, whoever, X amount of money to use all of the songs from a certain catalog or multiple catalogs. And so since they're covered, the venue or the festival itself is covered, then the DJ technically has the right to be able to use it because they've already paid the owner for that use of their song. So using a sample in a live set is a non-issue if these things are in place, and that's that blanket license. And then also, it's just like obviously it makes sense that the DJ has to have purchased the music from an MP3 file, a CD, vinyl, that sort of thing that's being used during the set, just because they have to own the music themselves. So this has kind of become a greater issue, and this is kind of what the original question from me in Logan's video was harkening back towards, is just that legal issues arise when live DJ sets are recorded and then posted to other mediums. So that's why Flume released a remix of Tennis Courts by Lorde, and he plays it in his live set a lot of the times, and that's completely a non-issue because that blanket license is there, he's paid for that song. But since it was posted to YouTube, to Spotify, that's when the legal issue came up because he hadn't actually paid Lorde for like the right to use her song. And so these things could be YouTube, Mixcloud, SoundCloud, etc. And the recording itself of the set, that audio-visual recording that's being produced at the same time, makes it a fixed work. And so that's when the legal issues arise. So they must obtain permission to post these things from the owners of the copyright, and they must pay royalties to the copyright owners for both the public performing right, master use right, and the derivative work right. So as far as 2020 goes, there was certainly an increased number of live stream sets in 2020. Obviously, we were all quarantining, and so we thought it would be a great way to, keep live music going a little bit in our own homes, right? But for DJs, it's actually created a fair amount of issues, and a lot of DJ sets were actually taken down maybe halfway through on Facebook, or after they're posted to YouTube, they're completely taken down, that sort of thing. And a lot of people were tuning into these events, which is why it was such a large-scale thing that was happening. And so since there were an increased number of live streams, they were creating fixed works as they had audio-visual being produced at the same time and being published pretty much immediately. So the live streams create a need for the master use license, and then since it's a video, a sync license, and then a public performance license because it's being streamed on the internet. And so there's basically two types of live streams legally, and so one is the pure kind of live stream, and that's when somebody were to record their live stream, but they don't post any final recorded version of it. So on Instagram Live, somebody maybe DJs a whole set, but then it disappears after the recording itself, so there's no record of it, I guess. So they would need a master use license, and then the platform itself would need a public performance license, versus an archived live stream where somebody's taking a video of their set and then they save it afterwards and it's published to whatever platform it's on. The platform would then need a synchronization license and a blanket license or a master use license, and then the artists themselves would also need a sync license because they're the ones using the audio in the song. So the Digital Millennium Copyright Act is what forces the platforms to kind of ensure that these users are not violating copyright. And so they each kind of have their own, each method, like YouTube, Facebook, Instagram, and Twitch. Those are the main ones being used. They each have their own method of copyright enforcement, or some of them have blanket licenses like YouTube and Facebook, things like that. So YouTube uses Content ID after their live stream. So they basically go through and try and use digital technology to match up where they think that other people's songs are being used, that sort of thing. And they basically run it through a database. Facebook has actually like paid for more blanket licenses for their gaming platform, that sort of thing. So each one kind of has its own way of enforcing these copyrights, but it does mean that the DJs are at a higher chance of getting their sets taken down if these blanket licenses are not in place. So the future of this, most live stream platforms are obtaining like new licenses and trying to figure out how to pay these artists, just because all these artists were putting out free content basically during live streams, and the artists themselves performing weren't getting paid, and then the artists, like the original songs that they were using, that they were performing on these live streams, weren't getting paid. So I think there's going to be a lot of new regulations in according to that, just because I have seen a lot of live streams continuing past COVID and past the emergence of some of these newer live events coming up in 2021. So it should be interesting to watch how that changes. And then a new like subscription service has also come out for DJs called Mixcloud Live, and so they can basically buy Mixcloud Live Pro, and then they have basically a blanket license to live stream whatever sets they want to. And so this is something that could be moving towards in the future. It's just something interesting to consider the legal ramifications of. And then obviously as live music continues to open back up, DJs will continue to play live remixes or remixes in their live sets. I don't think that's going to stop anytime soon. And as long as those blanket licenses are in place, it's perfectly okay for them to do so. So I just thought this was a really interesting topic, and I know I personally am very into the electronic music sphere right now, and so I just thought it would be interesting to consider all the legal ramifications of this, and it's definitely something I've considered when watching it live. So yeah, I hope you guys learned a little bit and enjoyed going a little bit further deeper into performing rights. And then these are my works cited. So yeah.